During Reconstruction, Congress passed the Civil Rights Act of 1871, also known as the Ku Klux Klan Act. The law was enacted specifically to combat Klan violence and to provide for federal enforcement of the equal protection rights of newly freed slaves as guaranteed under the 14th Amendment. Over a century later, in Haddle v. Garrison, the United States Supreme Court was asked to interpret that law in the context of a contemporary employment issue. Two officers of Healthmaster Incorporated, Jeanette Garrison and Dennis Kelly, were charged with Medicare fraud. Michael Haddle was an at-will employee of Healthmaster. Haddle fully cooperated with the criminal fraud investigation. He complied with a subpoena that compelled him to appear before the grand jury, and he agreed to testify as a witness at the upcoming criminal trial. In retaliation for Haddle's cooperation with the federal authorities, Garrison and Kelly conspired with another Healthmaster employee to have Haddle fired. After he was terminated, Haddle filed suit in federal district court against Garrison and Kelly. He brought claims under Section 1985 of the Civil Rights Act of 1871, along with several state law claims. Haddle sought damages for Garrison and Kelly's attempts to intimidate him into not testifying and for their role in the conspiracy to have him fired. Garrison and Kelly filed a motion to dismiss for failure to state a claim upon which relief could be granted. The district court granted the motion. The court relied on a previous decision from the United States Court of Appeals for the 11th Circuit that held because an at-will employee has no constitutionally protected interest in continued employment, an at-will employee's termination isn't an actual injury as required by the statute. The 11th Circuit affirmed. The United States Supreme Court granted cert.